the nubbum, give me the case law. No, this one. My lords, as far as the nubbum issue is concerned, my lords, again, that is something that I don't need to, we've addressed your lordships extensively on. And the principal concern, my lords, there was one, and especially when para 238 onwards and Justice Mishra dealt with it, was that constitutional proprietary demands that after the introduction of the 10th schedule, if that speaker within the period of the notice and the date when it's actually held alters the pool, what happens? And they relied on what in the Constituent Assembly debates, including Dr. Ambedkar's reference to the 179C of the then members. The then member argument, my lords, even then emphasized on not just present on voting, but the emphasis was on the pool of the House. Now, that is the exact principle which nubbum also follows. That if between the day of the notice to the date when the resolution is moved, if you alter the pool, you do not then reflect the correct composition of the House because you've altered it in a manner to suit yourself. And there is a conflict of interest as far as that is concerned. Now, my lords, an argument which was sought to be then made was that Article 181 provides that the Speaker cannot preside over the House only on the day of the resolution of the removal of the Speaker and not from the date of his removal as communicated. That was the argument on 181 made. But what is 181? 181 is also an argument to say that you cannot be a judge in your own cause. You should not on that day, for instance, not count certain votes, carry it out in a manner. The very principle of 181 is what is also applied. If at all 181 serves my argument, furthers my arguments, because what nubbum says is that given the introduction of the 10th schedule, there would be a clear conflict of interest. And in any case, there's a timeline provided therein. Within that, you decide your removal within the timeline provided, and then go ahead and uses the word that if a speaker is confident, he can continue. But the danger, the flip side to it is, my lords, a speaker's election, if he proves his majority, is not questionable. But what is questionable is a disqualification at the end of the day. So they said that in a matter like this, first show your majority and then continue with it. So to say that the Constituent Assembly debates were to the contrary is wrong. Even in the Constituent Assembly debates, firstly, they were dealing with the removal of the Vice President and other issues. They weren't dealing with 10th schedule at all. There was no 10th schedule at that stage. The then members was interpreted in the context and to say that the House composition on the day the resolution is moved is in that context. To read the resolution is moved, and in nubbum the court was wrong in reading it from the day of the notice is completely wrong. Because if the court doesn't read it the way the court has read, as the court has said that this would have led in a matter like this to sustain a robust vitality of the growing constitution were the words used, and to avoid any conflict of interest. This would be the most appropriate constitutional and ethical argument to tell the speaker to do it in a time-bound manner as far as you are concerned, and then go ahead with it. So my respectful submission is, my lords, nubbum requires no reference, lays down the correct law, requires no reference to a larger bench. Now, my lords, lastly, to end, my case law note is already with your lordships on each of the propositions I have given. So, my lords, effectively, if everything that is annulled is their argument, then Mr. Thackeray's voluntary resignation should not have been accepted because he resigned. He should not have been, they should have continued. The governor should not have acted in his constitutional capacity to invite the largest party as it then saw, or the coalition, to come and form a government. The confidence motion in the House reiterating overwhelmingly the faith in the new government and the new speaker needs to be reversed. The governor ought not to have administered the oath of office to Mr. Shinde. The speaker ought not to have been elected by the House, not once, confidence reinforced in him again. So everything needs to be annulled because everything relates back to that one day when disqualification was incurred. And because the speaker was not, or the deputy speaker was not allowed to decide that, Everything that has happened is vitiated. And in the process, whether you refuse to face the floor test, you did not have the confidence of the House, is all immaterial. And a government which overwhelmingly proves its majority, everything should be annulled. And despite all the law that your lordships have laid down, that every member is entitled to vote on the floor of the House, irrespective of his disqualification pending, should all be ignored. My lords, in Navam, I must also lastly point out to your lordships, subject to correction, I am instructed to say that apparently a review was also filed against the judgment in Navam, raising the same grounds of challenge. And it also raises the same interpretation of all the then members to be the date on which the vote takes place. And the Article 181 argument. And that review was also dismissed. Now, my lords, is it fair to re-agitate the same issue all over again before another constitution bench is another argument for your lordships' kind consideration? My lords, I'm extremely grateful. Your lordships are kind enough to call upon me again. I'm very grateful for that.
Thank you, Mr. Darkhold.
I'm very grateful.
Yes, Mr. Jethani.
Lords, I have a note, which is note K in your lordship's record.
Jethmalani, we have 44 files on PDF, all part of the written compilation.
Well, I empathize with your lordships, but it's just note K.
Written on behalf of OCX. Last one. 17 pages. 17 pages?
But there's no PDF. I'm told there's no PDF.
17 pages. 17 pages.
K.
Okay, na?
It's a separate document. But
It's a 7-page document.
it's a separate document marked note K. But I would, for the sake of saving time, I would run through that note a little bit so if your lordships could have it. Thank you. Lordships got it?
I think we can run through the 7.
I beg your pardon, madam?
We can run through the 17 pages.
But it'll be difficult. It'll be a spillover.
ये मुझे में नहीं है डाउनलोड कर देना
Now, it's tried to state that every case depends to a large extent on its own facts. My learned friends have taken recourse to some facts, but I propose to deal more substantially with facts and only incidentally with the law, because a lot has been said on the law. To point out, Manoj, that the fundamental propositions of law which my learned friends have raised in this case, on the facts of this case, don't arise at all. But Mr. Salve has said something on it in his brief submission. I'll just expand a little on it. But essentially, the 2 points of law, as I understand, in sum and substance, what it boils down to is A, the question of deemed disqualification, but to use that term which they've sometimes used and sometimes steered away from. The question of deemed disqualification, i.e., they were liable to disqualification. The disqualification never took actual place, but they were liable to be disqualified. And consequently, as a result of that deemed disqualification, the second proposition of law, and that is that the court must set the clock back, relying mainly on Rana, again, extensively dealt with by my learned friends, Mr. Salve and Mr. Kaul, and set the clock back completely, because the concept of deemed disqualification, since it dates to the date when the acts entailing disqualification took place, are the ones that are relevant for the purpose of disqualification. So you must look at that time. Now, a brief conspectus of facts. As I pointed out earlier, when we were dealing with referral, there's a very short time span, and that's between 21st and the 4th. Well, it's important to note that while discontentment and division commenced from the very inception of the post-poll alliance of the MVA government, the commencement of irreconcilable differences occurred on 21st June. That's the first date. The differences chiefly centered around the disinclination to continue with the MVA alliance, which, as per the Eknath Shinde group, was causing serious turbulence among party cadres for 2 reasons. The Shiv Sena had entered into a pre-poll alliance with the BJP for the elections held in November 2019, and their voters and cadres were aggrieved by the betrayal of that pre-poll alliance by the constitution of the MVA coalition government. And 2, that the party cadres were finding it difficult to reconcile long-standing ideological battles with their coalition partners, namely the Congress and the NCP, and the cadres of the different party in the coalition, far from working in cohesion, were at loggerheads with one another. Now, there are many statements even before the 21st. Ministers of the then Shiv Sena, the joint Shiv Sena, many statements expressing dissatisfaction in public. MLAs have complained about it. So this is all, 2021st is the only date which this court has a record of. But it happened much earlier. Now, the first steps, as per the record of this court, that led to the rendering the differences irreconcilable were admittedly initiated by the Uddhav Thackeray group. One of the first salvo was filed on 21st June by the Uddhav Thackeray group. In its resolution of 21st June 2022, a minority of members of the Shiv Sena Legislative Party in the Assembly removed Eknath Shinde from the post of group of Shiv Sena Legislative Party, of leader of the Shiv Sena Legislative Party. On the same day, the chief whip, one Sunil Prabhu, issued a party whip summoning all members of the Shiv Sena Legislative Party to attend the meeting at the CM's residence on the same day. The removal of Eknath Shinde, this is where it starts, because my Lord Justice Kohli was asking about, could there be no reconciliation? Was there no party forum to resolve these differences? The first salvo that was filed was on 21st June, and it was a very drastic salvo filed. The salvo was you remove him as a legislative leader. After that, it became irreconcilable. Nothing could be done. And I'll tell your Lordship what happened afterwards. Those facts are very important as to why the party forums became irrelevant. What was done by the party organization and the party leaders, including people in their party leaders in parliament. The removal of Eknath Shinde as a leader of the legislative party indicated an intention on the part of the Uddhav Thackeray faction to escalate a simmering dispute to a point of no return. Now, neither the resolution nor the whip issued by the chief whip were communicated to any of the Shiv Sena MLAs who were not signatories to the resolution. Eknath Shinde and the other MLAs only learned about the resolution of the whip on 21st June through media reports of the same day. On its part, the Eknath Shinde group, consisting of 34 MLAs, passed a resolution on the same day setting out various grievances with the party leadership for forming the NDA government and the impact that it had on the party, its organization, cadre, and voters. Now, my lord, all this has been read, so I'm not going to read in detail. But, my lord, your lordships will recall that the letter of 21st June was a response by Eknath Shinde to his removal, in which he pointed out that it was not just the legislators, but it was also the cadres who were disappointed. So the organizational disappointment along with the legislator disappointment were both highlighted in that letter of 21st June, which, as I said, was a response to their letter. By the resolution, 34 MLAs reaffirmed Shinde as the leader of the Shiv Sena legislative party, removed Sunil Prabhu as the chief whip with immediate effect, and appointed Mr. Bharat Gogable as chief whip in his place. The resolution was sent, this is important, my lord, the resolution was sent and received by the governor of Maharashtra. So the governor of Maharashtra, to answer again, my lord, Justice Kohli's, had his first intimation of a simmering dispute on the 21st June. The resolution was sent and received by the governor of Maharashtra, the deputy speaker of the Legislative Assembly, and the secretary of the Maharashtra Legislative Assembly, both by email and a hard copy. The 34 MLAs on the same day, we're still on 21st June, also sent a notice to the deputy speaker, Mr. Zirwal, of intention to move a resolution for his removal under Article 179C of the Constitution, read with Rule 11 of the Maharashtra Assembly rules. And I'll read those rules in a minute because they are quite important. They deal with the 14-day period notice prior to consideration. And the rule and the article are both mentioned in that letter sent to the governor and the deputy speaker. On the ground that he no longer enjoys the support of the majority of the House and accordingly has lost his right to continue as deputy speaker, in view of the decision in Navam Rebia, the deputy speaker was requested to refrain from acting as deputy speaker till such time as he could prove the support of the majority in the House. Now, my lord, what are the contentions of the petitioner? First, that if the respondent had a grievance with the party leadership, he ought to have sorted it out within the party and not sent the notice under Article 179C to the deputy speaker. That the notice of the deputy speaker was flawed because in any event, the deputy speaker's disability under Article 181 commenced on a consideration of the notice of a resolution was removal and not when notice had been given of the intention to move the resolution under Article 179C. The decision of Navam Rebia, to the contrary, needed reconsideration. And the resolution of 34 MLAs of Eknath Shinde group was without jurisdiction as Eknath Shinde had been removed as the leader of the legislative party in the House. That's by their letter of 21st June. Now, my lord, this is the response of the... As regards the reply to 2.1 above, the question of resolving grievances against the leadership within the party did not arise, as the party leadership had precipitated the issue and made any reconciliation impossible by unilaterally and illegally removing Eknath Shinde as leader of the legislative party. Well, no hearing, no notice, nothing. This unilateral removal had to be viewed as a hostile act, which would be followed by more serious consequences. In the circumstances, the letter to the deputy speaker under Article 179C was a protective step against any escalation by the Uddhav Thackeray group. Significantly, at this stage, now this is important, the Eknath Shinde group did not take any step in the direction of unsettling the government by withdrawal of its support, necessitating a floor test. Now, my lord, on the applicability of Nabam Rabia. Although on facts, it's my respectful submission that Nabam Rabia's, the case doesn't arise at all on the facts of this case. Nevertheless, my lord, if your lordships do intend to say something about Nabam Rabia, my lord, this is my respectful submission that it should be to reaffirm, especially Justice Mishra's view. My lord, I concede that the then members' part of 179C has been wrongly construed, particularly in view of the Constituent Assembly debates, and particularly the view of Dr. Ambedkar in that. But, my lord, there's much more to be said apart from the then members' part of it, for reaffirming Justice Mishra's very eloquently put view in that separate judgment. On the applicability of Nabam Rabia, the construction of that judgment regarding the time when the Speaker's disability under Article 181 commences was established law by a constitution bench, and the Deputy Speaker was bound to act according to its dictates. Well, that's an aside. In any event, whether you like Nabam Rabia or not, the Deputy Speaker was bound by its mandate, and its disobedience at that particular point of time is a serious breach on his part of his duties and the role envisaged for him by the Constitution: impartiality and, of course, obedience to the law. As regards the correctness of the view taken on this aspect in the decision in the Nabam Rabia, it is respectfully submitted that this honorable court should reaffirm the view in Nabam, most emphatically enunciated by Justice Mishra, that when there is an expression of intention to move a resolution. Now, may I just read paragraphs 236 and 238 of Justice Mishra, just 3 paragraphs at this stage. It's PDF 1167. Well, because, my lord, he makes the case for what he says compelling. (236). In this regard, lordships got it. It is essential to understand the character of the 10th schedule. The 10th schedule to the Constitution has conferred adjudicatory powers on the Speaker. While deliberating on the constitutionality of said schedule, the majority in Kyoto's case has stated, the Speaker Chairman, while exercising powers and discharging functions under the 10th schedule, act as tribunal adjudicating rights and obligations under the 10th schedule, and their decisions in that capacity are amenable to judicial review. However, having regard to the constitutional scheme of the 10th schedule, judicial review should not cover any stage prior to the making of a decision by the Speaker's chairman. Having regard to the constitutional intendment and the status of the depository of the adjudicatory power, no quia timet injunction actions are permissible. Now, I'm not pausing there for a minute. If there is a constitutional violation by the Speaker, the actual order of disqualification, that is not contemplated by Kyoto's judgment. For instance, when he did not comply with the notice period, and that notice period is under Rule 8 of the 10th schedule, a court could intervene, because that was a denial not only of natural justice, but a contradiction of the rules framed by them in their wisdom under Rule 8, under Clause 8 of the 10th schedule. And Kyoto says something about the sanctity of those rules. I'll come to that later. At para 6.1 of the 10th schedule, to the extent it seeks to impart finality of decision of the Speaker's chairman is valid, but the concept of statutory finality embodied in paragraph 6.1 does not detract from the abrogate judicial review under Articles 136, 226, 227 of the Constitution, insofar as infirmities based on violations of constitutional mandates, malafide, non-compliance with rules of justice, and perversity are concerned. But Kyoto says more on paragraph 8 rules, and I'll come to that. And the rest of that is, you'll also just see J, that contention that the investiture of adjudicatory functions in the Speaker's chairman would by itself vitiate the provision of the ground of likelihood of political bias is unsound and is rejected. The Speaker chairman hold a pivotal position in the scheme of parliamentary democracy and are guardians of the rights and privileges of the House. They are expected to and do take far-reaching decisions in the functioning of parliamentary democracy, vestiture of power to adjudicate questions under the 10th schedule in such constitutional functioning should not be considered exceptionally. Now comes Justice Mishra's own enunciation. The aforesaid reasoning eloquently speaks of the power, position, and the status the office of the Speaker enjoys under the Constitution. It also states about the scope of the fiction. The court has constricted the power of judicial review and restricted it to the stage, carving out certain extreme exceptions. It is because the Speaker, while exercising the authority stroke jurisdiction, exercises the power of constitutional adjudication. The concept of constitutional adjudication has constitutional value in a parliamentary democracy, and constitutional values sustain democracy in a sovereign republic. The Speaker is expected to maintain propriety as an adjudicator. My Lord, when I show the facts of this case as subsequently transpired, I will show your lordships that the Speaker repeatedly violated his constitutional duty as envisaged. The Speaker, when functions as a tribunal, has the jurisdiction authority to pass adverse orders. It is therefore required that his conduct should not only be impartial, but such impartiality should be perceptible.